number of students who are enrolled in that particular school. We actually compiled some information. I apologize I didn't have this in advance to distribute to the board, based on the number of children who have indicated that they plan to attend the turnaround academies or who have defaulted to that choice. The children who have defaulted are the children who have not made a choice, and they're actually by far the greatest number. And let me tell you what those are.
They have that information in the handout I gave you.
Okay, but that's not part of this proceeding. But but I'll present the numbers. The department, last fall, Emma Donnan had 850 students. So far, 583 have signed up. Arlington, 1224 students. So far, 585 have indicated they'll be there next year. Howe, 1024. So far, 572 have indicated that they would be enrolled next year. Manual, 712. So far, 445 had indicated that they plan to attend. That is a difference of $5,956 and $5,956,893. So almost $6 million. I mean, that's a significant difference. And if you actually base the per pupil funding annualized on the children who are have indicated that they plan to enroll, and of course we recognize that number could vary considerably. It could grow, it could decline. Emma Donnan would be receiving $10,689 per pupil. Arlington would be receiving, and again, these are annualized numbers, $15,340 per pupil. Howe would be receiving $13,125 per pupil, and Manual would be receiving $11,730 per pupil. Now, as I said a few minutes ago, we don't object to the turnaround operators receiving full funding in July based on last year's ADM. All we're asking is that, because that is the only number out there, but they're going to do another one in September. And we asked that they do a reconciliation so that the total amount of funding provided to the turnaround operators for the students who they enroll in the fall does not exceed what would have been the total per pupil amount for IPS. So whatever that number is times the IPS per pupil amount. And that's what we believe the statute says. And, the department has said, well, that's not how we treat other school corporations. Well, again, the statute makes clear, shall not exceed the per pupil amount. That's not how the funding formula works. That's not how school corporations are treated under the school funding formula. This is a provision to fund a contract. It's not a provision to fund a school corporation. So, again, we just encourage the board in considering this to look at what we believe is the legislative intent. And also, I've heard several board members say that they believe the money should follow the child. Well, interpreting it in the manner that the department has suggested runs completely counter to that philosophy.
I have 3 points to make. Number one, among the students that are identified, there's no guarantee the other percentage you're talking about are going to IPS.
Oh, yeah.
It's just
sorry.
projections. It's simply projections.
No, I meant to give that amount. So far, 973 students have indicated they plan to attend IPS next year. For that semester alone, that's $3.5 million in tuition support funding.
Again, it's just projections.
Exactly, and as we said in our letter, we understand we're taking some risk asking that the numbers be reconciled, because it could well turn out, it sounds like there's a lot of community engagement going on. It could well turn out that they end up with more students.
I have a couple questions also. You infer that you reallocate resources from students that are lost, say 200. I would really love to see evidence of that, because historically we've heard that there are a lot of corporations, and I'm not saying IPS is one of them, but statewide, who get ghost seat costs and hang on to that money. So the reallocation of that, the mobility rate, the dropout rate, where has that money been going if you in fact are reallocating if kids are shifting? And then lastly, I'm very strongly in support of using September as our baseline because that's a real number that existed, and you can't let a student walk in the classroom and then say, oh, by the way, we're going to readjust what you're worth. And historically that when an ADM count happens, dropout or the numbers the week after are sufficiently different.
If I may respond, September 2012 is a real number too, and I mean we all know.
But it's projected out.
But it will be taken during the semester in which these funds will be distributed, so there'll be an opportunity for subsequent reconciliation. That number will be counted. And secondly, we know what the number doesn't vary. Under the statute, the number cannot exceed 7,331 per pupil. That's the number. It doesn't matter if you have 10 pupils or 10,000 pupils. The number must be 7,331 per pupil.
And you say
And that's the corporation number?
Exactly.
And so that back to my thing, that's what's coming on the DOE 54 or
Yeah.
Yes,
so what number is that again, Debbie?
$7,331.56.
7,331. Okay.
No,
And 56.
Where is that coming from? Is that your base foundation you're getting now?
In the funding formula, the base foundation where every school starts
Right.
is $4,280 in the 2012
Right,
formula.
right.
That amount then is multiplied by each individual school corporation's complexity index.
Okay.
And you're adjusted upward or downward,
Okay.
depending on what that dollar amount comes.
But not from the 42,000.
Not from the 42,000.
The 4,000.
The 4,000 is the base, plus
Right.
the additional you get for your complexity index.
So which
So-
is the base?
$4,280.
Right, that's the base.
That's the base
So
foundation
nobody's gonna get
amount.
less than
So nobody should get less
4,280.
than that amount. Then the formula looks at what you've received in the prior year, and you're adjusted upward or downward for you to try to get to what your school corporation's foundation amount is. IPS is well above their foundation amount, so we're being brought down every single year in the formula. Okay? Is that understood? Does that answer your question?
Brought down because?
Excuse me?
Brought down because of?
Because we're above what is considered the foundation
I get it.
funding amount.
Okay. I just wanted to hear it.
May I ask a question?
May-
on some math?
May I I just want to expound on something because what Libby told you in terms of the way we see reconciling this whole thing. Based on April 30th enrollment numbers, right now in the schools, you should know that in Emma Donnan, they have 63 students who have indicated they're going to go to the takeover school. However, they have 520 students who haven't made a choice. And all the students who did make a choice, we defaulted them into the takeover school. We didn't put them in another category. So part of the reason that we're concerned is that a lot of these default students could change their mind either way. But right now, the numbers are such that we think it's only fair that some type of reconciliation occur after we get the real ADM number in September. Because when we're going down, when we get to Arlington, 59 students have actually signed up for Arlington. 526 have they're defaulted, but we gave them to the takeover organization as a default. We don't know what they're going to do. When you get with Howell, 189 students have signed up for Howell. However, 383 have defaulted into the number that Howell is using. We still don't know what they're going to do. At Manual, 112 students have signed up for Manual. 333 have defaulted into Manual because they didn't make a choice. And so we're not saying not start off like they're saying, but we're saying when we get the real ADM number, We want a reconciliation between what's real and what's projected on paper from,
Let me ask you, or Libby, how you would envision that reconciliation working. I mean, the charter schools, just like you would have to make decisions about hiring, about employment contracts. How do you kind of, how do you do that reconciliation in any way that's
Are you talking about the
practical?
reconciliation done by the department that we're suggesting? Well, I think, first of all, as they head into the school year, the turnaround operators should be, just like IPS is, gathering information about how many students they think are going to attend. And, the one thing that the turnaround operators should know from both the statute and the board's own rules is that they are going to get $77,331 per
56
pupil.
cents.
And, so how much they end up getting depends on how much students show up. And that is exactly what school corporations are living with now under the dollar follows the child. When a school corporation starts in the beginning of the year, they don't really know when they plan their budget how many students will leave to take a voucher, how many students will move.
That's what
Again,
they-
and I think the
Well,
key.
they don't have to do that reconciliation, Libby. They're getting the number based on the last year's ADM.
That's
So
true,
how
and
are-
I think it's
so
important.
I just want to hear you explain how, not in a detailed way, but how you think that kind of reconciliation mid-term in a sense, but somewhere in that first 6 months is practicable.
Well, let me explain, okay? The school funding formula that the department says is applicable here, we all acknowledge, it will fund school corporations, not individual schools, but school corporations, for the fall semester of 2012 based on an ADM count in 2013, or in 2011. The provision that we are dealing with is a provision to pay for a contract. And it's a contractor who, is being hired to serve a certain amount of students. And I would say that it can be done just like you would in any other contract, where you project how many students you're going to serve, and then you get your money for the contract based on the student. Again, IPS and the turnaround school operators have been trying to gather enrollment information. We have preliminary numbers now, which should give them a benchmark of where they're starting. But the statute is clear that the total amount of funding they receive in the first semester of 2012 may not exceed the per pupil amount for the affected students. And I would contend affected students under any plain reading of the statute means the students that they are serving.
Are you suggesting that the reconciliation should take place each year, the turnaround?
No,
Or just
this
establish
is
the
a one-time
baseline?
only
time.
occurrence.
One
This
time.
is a one-time only occurrence. After this semester, the turnaround, frankly, it could occur. It's been our understanding that the department is intending to give separate school numbers to the turnaround academies after this semester. So they'll stand or fall on however
Stand
numbers.
alone.
Is that accurate? Yeah. So
Say
this is a
say that again.
one-time
I
occurrence.
didn't follow that. Say that again. Say,
DOE intends to assign a corporation number to the turnaround organizations so that they would have student counts and be in the funding formula the same that any other school corporation in the state would be.
So beginning in January of 13, they're going to have a school number.
That's our
and
understanding.
go through the formula. Melissa, is that what you're
Let me
understanding?
qualify that. We're still
Okay.
working through that to be sure that it fits with all of the other systems, the data systems and everything, to be sure that, nothing will crash by changing. So the decision hasn't been finalized yet.
Wait a minute, there's nothing been finalized on the number, assigning the number?
Correct. I'm trying to be sure that it all fits together in terms of, that this won't throw off of the different systems that we have at the State Department, data, et cetera. Make sure that everything, when we input it, that it doesn't throw off any of the calculations.
Can I ask another question on some math?
Yeah, you may ask as many questions as you need.
We have a projection, because of default, where approximately, was it 900 students would end up in other IPS schools? How many students are we talking about, excuse me?
To get to that $6 million
No.
mark.
Pardon me? How many
Ba-
students?
No,
ba-
that,
The present schools that are being taken over, they were in, these years had struggles, so we decided this year to take them over and give new operators. And based on your projection, you didn't default, how many students are you gonna pick up in the schools you're still operating?
May I ask that? Mr. Elsner, based on the numbers I gave you, including the default and the actual enrollment,
Throw the default
that's
in.
2,185 students.
So you're assuming the default kids are gonna stay at Howe and?
No, I'm assuming the default kids are going to wake up one morning and make another decision.
Okay,
And they're
but
going to
right-
be either
but Right
or.
now, what do we have? Right now, the defaults are staying at Howe, they're staying at Manual, and they're,
Correct.
Right,
Yes.
correct.
okay, based on that, how many students are we talking about?
The total of the ones I gave was 2,185 students who are either enrolled or defaulted, but the default number is almost 4 to 1.
Okay, but I'm trying to just get to one number, though.
Okay.
If we have the students who have specifically enrolled, stayed in Howe, I'm using Howe for an example, or defaulted to Howe, the present schools we're taking over, based on projections, we're gonna lose how many students?
there are 973 students
That's
who
right.
have affirmatively indicated they plan to attend IPS
IPS.
next year. Now,
Now, that would be like a nominator, so, and they're gonna go to how many schools would you expect? I mean, what are you kind of projecting? You know where they're going if they've said they're coming to a different IPS school. Then
Yeah.
do you know how many different schools they're going to?
They will be going to one of about 4 different high schools.
And those 4 high schools represent how many thousands of students?
I don't have that in front of me right now.
I'm just, we're kind of mixing and matching here. You're funding a school. There was a school that was continually struggling, and we hired different operators. So there's a baseline there, but a system has, you could have a pretty big denominator, and a denominator you could throw, okay, 3 kids end up in this class, 2 in this class, 1 in this class. I was trying to get some sense of the math. You're dispersing 700, 800, 900 students based on present projection over how many thousands of students and then how many buildings, and how does it sprinkle in?
I think your particular point is that in our system, we have more ability
There's some elasticity.
to accommodate students either way. With their number being smaller, they will have a less ability
less
for that.
elasticity.
And that's correct.
but
I was just trying to get a magnitude with the mathematics. I was thinking through a mathematical formula.
But I guess I would like to, just remind the board that its discretion does not extend to the ability to provide what in essence is a regoster to, if they lose students, then they get extra money because they can't absorb it. The discretion is limited by the statutory language that says the amount cannot exceed the per pupil amount per student.
The formula or the amount?
Well, let me pull up.
Reread that one.
I'll pull up the actual language of the statute. It says, the amount withheld under this subdivision, and that's 2031 9.53D, may not exceed the total per pupil funding for the affected students. Now, there have been attempts to define per pupil funding, which language was put in Senate Bill 384, which got caught up in a mess at the end of session and died. I believe the department, in its proposed rules that were adopted to move forward with publication, did define tuition support as basic tuition support, special ed grants, career and technical education grants, primetime program grants, and any grants funded by the General Assembly that are attributable to the affected students. And that was in 384. But right now, it's tuition support, or it's just not defined.
Are there any other?
Or total per
Yes.
pupil funding is not
I have
defined.
a question.
Please go ahead.
Let's just say you do this one-time reconciliation. So what's the difference in the amount? You can't give a projection?
Well, based on where we are today, it's about $6 million.
And that's,
Okay, I'm sorry. Yeah, I'm hearing a couple things, and I appreciate, I think Neil's asked a good question. And one of the questions that Neil asked is, if we do a reconciliation in September, there could be a drastic drop in the amount of money that the takeover groups are going to have. Because what I'm hearing IPS say is, I'll go to Arlington. You said 59 students have actually chosen to stay at Arlington, and the rest have not chosen. So there's a number of 585 kids at Arlington.
Yeah,
And so, projected. I mean, because 500, between the kids who have chosen and the kids who have defaulted, there's 585 kids.
Right.
Yep.
Okay. And if you take 585, whether you take it times the $7,331, or you take it times the number that was given to us by the DOE, you have a number. And that number, that 585 number, is going to allow the takeover academies to make decisions. They're going to know how much money they have. They're going to know how many people they can hire. They can do a variety of things. If we say they're going to get the DOE number, and we go into September, and that number is significantly less, and we make a reconciliation, they're in trouble.
May I address this?
Well, okay. Let me finish my thought. Then I have no problem doing that. But they would be significantly in trouble because of people they had hired and put in place, and maybe be under contract. I think they'd be in significant trouble. And on the other side of the coin, I'm saying that if we go with the DOE numbers times the $7,331, they could be, and that number's way low, they could be extremely lucrative. They could be extremely lucrative, maybe at a detriment to other kids in the IPS system.
Right.
So I think that's really our dilemma. Am I right there, or am I out of line?
no, that's what that's where I was going.
Let me just interject, if I may, one just procedural thing. I'd indicated in my preliminary remarks about how the proceeding ought to run, that there was a period of time in which each party was allowed to make a presentation and answer questions. Then there's time. Then there's another step, as I see, for board discussion that I do not think should involve engagement with the parties. So I'd like to allow any last opportunity for the board members to ask questions directly of either IPS or the department. And then what I'd suggest is that,
Mr. Pickett?
yes.
Debbie Heinlein had a statement as well for IPS, and she may be allowed to present it. And
Of
may
course,
I?
I'm sorry, I didn't
May I?
realize
And
that.
I thought I did. I'm sorry. Maybe I didn't hear a question that Mr. Pettibone was phrasing. But may I make one final statement before I end?
Yes, of course, Libby.
Basically, we understood the dilemma that you're posing, which is why in the letter that we sent on April 27th, we suggested that the turnaround schools be funded initially on either the 2011 ADM count or the projected enrollment. And we suggested the lesser of, so they wouldn't have that sticker shock in the event the enrollments came in much less than anticipated. And that would make the adjustments then much less painful. And we suggested, those reconciliations could begin in the final 3 months of the second half of the year, and that a similar methodology be used for the special education, because that count is done December 1st. So those reconciliations would have to be done after the end of the year. But yeah, we recognize they need startup money and they need some certainty. And so, it made sense, for them not to start receiving money that was at an amount that far exceeded projected enrollments. Otherwise, they would end up in trouble.
Okay, thank you. Now, you have a separate statement?
Yes.
Is it cover separate topics than the one that Ms. Sersniak covered?
It makes some points differently than what Libby has pointed out.
Okay, may I ask you to try to, in the interest of time, we obviously are going to have to go over our normally planned schedule, and that's appropriate, but may I ask you to please try to be as succinct as possible while still making
Sure.
the points you want to
Sure.
make? Thank you.
Most of you on the board know who I am. Approximately 3 years ago, Dr. White recruited me to become the CFO for IPS. Prior to that time, I had worked for 14 years with the Department of Education in the Division of School Finance. So I feel like I have a unique understanding that business managers and even superintendents in the state don't have regarding the funding formula and student counts and how those counts are used to fund schools. Staff at the DOE has tried to characterize this situation as a transfer between schools like any other transfer that happens around the state of Indiana. This situation is anything but typical. We're charting unknown territory here without the benefit of the law to determine how we proceed. If a student were to come to IPS from any other school corporation in the state at the beginning of the 2012-13 school year, IPS would not receive any money or funding for that student until January of 2013. You can equate this to what a brand new charter school opening up has to go through. They're not in the funding formula to receive dollars in their first 6 months of operation either, and they're required to get a common school loan to cover the operating expense for those first 6 months of the school year. So we're looking at apples and oranges in the way that we're handling things. Based on the students who have chosen to attend the turnaround school next year and those that have defaulted, which were ones that did not make a choice, as of last Friday, approximately half of the students that are in these 4 turnaround buildings would be staying with IPS. If IPS is allowed the total, if DOE allows the total funding of the September 2011 account to go to the turnaround organizations in the first half of the 2012 school year, IPS would be shortchanging all students, not just students from those 4 turnaround academies. We believe that to be about the children, a funding approach for the turnaround schools and IPS can and should be fair to both sides. There was a point in time when you could not pinpoint where a student was being educated at any particular point in time. However, we have gone far beyond that point with our data collection process through the STN Application Center. Schools on a weekly basis submit information based on those students in attendance, and it even includes information on the expulsion of students. Since we have the capability, I don't believe there's any reason at this point in time that point-in-time information couldn't be used to determine a more realistic funding amount that the DOE could legitimately provide to the turnaround organizations from funds that IPS is projected to receive through the remainder of 2012. If the DOE does not believe this is feasible, then we believe that there should be a truing up after the September ADM count. IPS wants the funding to be fair and equitable for the turnaround organization and IPS. And the only way to do this is to make sure that not only tuition support, but special education funding is based on the students at the respective educating entities when school starts this fall. Another issue that has not been talked about in any of our discussions is IPS is still part of the DSEG phase-out. There are students that reside within the attendance area of these 4 turnaround schools that are not eligible to go to the turnaround academy because by law they have to go to the township schools for their education. So that's a piece that has not been talked about in any way, shape, or form, but we'll have to figure out how that works. So, having said that, if you have any questions about funding or anything else, I'd be more than happy to take them at this time.
Joe, yes, please.
I just have some comments, and perhaps it's,
Can we get through a direct question?
I guess the
yeah,
only
this
thing.
is a direct.
Yeah, okay. All right.
It is
It's a
direct.
direct question to
Yes,
those guys?
Yes.
Okay.
Have we considered and discussed that, will there be a second count this year, 2012?
Statutorily, there's no authority for a second count in 2012.
In 2012.
12, okay. But in 2013, that begins, correct?
September 2012, we do a count, and I believe then there's another count that will be taken in February of
correct.
2013.
Correct, okay. And then my other question was, your consent decree, is that something that was established within your state, your school corporation, and can be, the Department of Justice is involved, and local corporations historically go to the Department of Justice to ask for waivers. Is that something you could consider for these
Are you
turnaround?
talking on the DSEG students?
Yes.
At this point in time, I would not think that you would want to go down that road. We're in the phase-out process, and the entire phase-out is to be completed by 2016.
So phase out, my question is related to the at-risk students, because I know where I live, they have a consent decree, and the local
That's not the
corporation-
way that the IPS's DSEG
Okay,
order
who
was.
ordered the DSEG?
Judge Dillon.
Who is he?
Federal District Court judge.
No, well, I didn't know if that was local, state?
No,
I mean,
it's a
what-
federal.
Okay. Well, so is the Department of Justice.
But the time frame you're talking about of going before any federal group to make changes, you're not going to get it done by the time school starts this fall. It would be, at the best, a year down the road before you would have any kind of decision made, at the best.
So you're comfortable, I mean, I'm just asking from a quality of school benefit for all the kids, for at-risk kids, and
Well, that was the whole point of the
I understand that.
the DSEG order anyway, was to give the racial balance.
right. I'm familiar with that, but my question is, you saw the turnaround coming. Are you comfortable that this DSEG arrangement is going to treat all these children fairly?
Well, they're being treated the same way today as they will be with the turnaround.
Doesn't-
We don't get to educate them based on the boundaries of the DSEG order. Those students cannot come to IPS for their education. They are assigned to a township school
Okay.
for their education.
Okay, I was thinking differently. I was thinking you were saying they could not go to the turnaround school
I don't
because of the
believe they
DSEG.
can.
Because of the DSEG order? Okay.
Because of the DSEG order. Because we don't today allow a student to decide, well, I don't want to go to Decatur Township, I want to go to Wayne or go to IPS. If
Well,
they're in
that's
the
what-
DSEG order, they have
Right.
to go where
Right.
their boundaries for the DSEG is.
Right, well, that was with the assumption that possibly the turnaround may meet that child's needs. Not be better, but meet that.
Well, unfortunately, we can't change what
All right,
the law says we
understand.
have to do.
I get it. Sorry about asking about the judge.
It's kind of old ancient history. I think.
Yeah, that's what I thought.
Jim, do you, or Melissa, have any questions that you would like to pose to IPS?
We do not.
Okay, do you have any last?
Neil?
Yes, Dave, sorry. Yes, please. Dave?
Let me first confirm with Mr. White that, Mr. White, I will not vote,
Okay.
but am I privileged to ask a question?
Yes, you are, of course.
It goes to Ms. Zerniak. Is it IPS's position that the word affected applies as of September 2012, and that's the basis on which you're making your position known?
Mr.
As
Shane,
opposed, for example, to affected by the fact that the Turnaround Academy approach and all children would be affected in September of 2011.
well, Mr. Shane, it's our view that the plain reading of the statute would be affected students are the students who are attending the Turnaround Academy. The department's view, affected students would include students who have graduated, who are no longer in the school corporation, who have left the state. And, I don't think you can reach that under any plain reading of the word affected.
So you're treating it as your position is the school's manual, for example, are no longer a part of IPS.
No, not at all, but the affected students are, I guess to take your point, to extrapolate on it, then they could receive school funding for, based on IPS's entire student population, which clearly would defeat the legislative intent of just funding these funding these turnaround operators at the level for which a regular school might receive money for students through the school funding formula. And again, as I said previously, IPS, allocates its resources based on the number of children who are there each school year. So if a school drops 200 in their enrollment, there's going to be some teachers moved.
Aren't you asking for a different definition of affected, though, for different purposes?
Affected is not defined in the statute.
I know. Well, that's what. So that's the case, but you're suggesting a clear, or what you called a reasonable interpretation of affected.
Well, again, that is
students attending. Hold on, just bear with me.
I'm sorry.
The students attending the Turnaround Academy, and yet the per pupil funding reference also refers to affected students, and that refers to the per pupil funding for the corporation. That's the $700,300 we're talking about. So that, by that definition, affected means every student in the corporation, doesn't it? And if not, what's the total cap? The language says the amount shall not exceed the total per pupil funding for the affected students. What's the per pupil funding for the students attending the Turnaround Academy? But that's the IPS corporation number, which suggests that the word affected refers to every student in IPS. Currently, yeah, which is what the department is proposing to use as the definition for determining the calculation of the funding, the ADM count.
No.
Again, had the legislature intended to put this in the school funding formula, it could easily have done so. It was in the same bill. Affected, to say that the word affected applies to every student in IPS and not the students who are being served by the contract.
Well, then, Libby, answer the very simple question. What's the per pupil funding for the affected students?
It's the number of kids who are being served under the contract times IPS's per pupil amount of $7,331.
That's not a per pupil amount. You're multiplying. I want the per pupil. This says if your interpretation of affected is correct, the statute says that it can't exceed the total per pupil funding for the affected students.
Well, for tuition support purposes, the $7,331.56 is the per pupil funding amount, because that's the funding amount in the funding formula based on your ADM count.
But that's right, based on your ADM count.
Plus special ed.
Well, we're just talking
Yeah,
about the tuition support.
that's of course,
But that's
all.
huge.
It's huge, but it still goes for everybody.
But Neil, they just shared with us a little while ago that their average is 10,000 to 15,000 per pupil going down the list of those schools.
The average would be if you.
Dave still.
Dave, go ahead.
Yeah, I'm sorry, I guess I'm under 6.2-9-4, and I'm looking at the language, and as I read it, it basically says the department is supposed to withhold an amount that the board deems necessary to make sure that the school's done right. And at least that's how I could read it. I'm sorry, wrong one. 9-5-3-E1. We're supposed to withhold from the state tuition support, blah, blah, blah. The amount determined under subsection C says the amount deemed necessary to fund operations for improvement implemented by the state board under this chapter.
That's
which
exactly what it
respects
says.
each Turnaround Academy. And then the next provision says that can't exceed the total per pupil funding for the affected students. I guess I would just note, and I'd be curious if IPS has a response, I guess in the form of a question. One could interpret that to say the department and board figure out that X is needed per kid, and that per kid can't exceed 7,000 whatever, as opposed to an interpretation that you look forward to September 12 and try to redo the funding formula effective September 12.
Well,
So I'm curious if
we-
IPS has a response to that.
We're not asking for the funding formula to be redone. Again, the board has the discretion to determine the amount that will be paid for the students who are going to be served, but it may not exceed IPS's per pupil amount under the funding formula. You know, and as Debbie Heinlein said, real-time counts are being done. There is no language in here that says, you know, the amount of per pupil funding is equal to the ADM count of September 2011.
Nor 2012.
No, but I believe you have to link back to the term affected students, and the aggregate per pupil amount of the affected students is whatever number you think the affected students are, times 7,331.
I guess we're back to my first question. You read affected students to mean as of September 2012, not those that were at the Turnaround Academy during the 2011-2012 year.
Yeah.
So you're interpreting it as a variance from the normal school funding process.
Exactly. This is payment for a contract. It stipulates how a contract will be paid. It's not school funding, such as the school funding that goes to a school corporation.
It's technically then, they're not affected students until 2012, until September.
That's how we would
Because
view
that
it.
school, because the turnarounds are not in operation.
Correct.
That's what you're saying.
And, see, that's, I don't know, I think,
This will be for discussion, but the state board, I mean, we're supposed to determine the amount of support they need to fund the option for improvement. These schools have been struggling for a lot of years with a lot of warnings and a lot of work been put in, and we had to put a new operator in there, and we want them improved. And so that's what we're determining, I think, under the statute.
Do we respond to that?
Are there any other questions from the board?
Maybe we respond to that?
Was that a question, Dan?
I was just pointing out we were taking different points of the statute, and Dave Shane was pointing that out, and I wanted to reemphasize it. And it'll be good for discussion.
But
I was going to say, at this point,
We probably-
does the board have all the material, all the written material, Libby,
Yes, I
that,
think so.
that you wanted to have? Is the record complete?
well, we were told that all the written material had to be submitted by.
And it has been submitted?
Yes.
I just want to make sure, that's all. I just want to keep
This
it.
being included?
No, it will not, because it has not been submitted. And that's one of the reasons I asked the question, is because there was some reference to it earlier. Is that going to be submitted as part of this record?
But, I mean, we don't have an objection to it being submitted.
I know you don't.
We don't like that.
How about you?
Yeah, we have not reviewed it, so it's,
So that sounds like you're objecting.
we are.
Okay, well, see, I think it's a little late in the day for that, and they've made oral testimony, so.
Okay. Let me just ask again, does any board member have any direct question for either party at this point? And if not, let me ask then that we now have whatever discussion we need to reach a conclusion and a decision. I guess it's appropriate for the parties to stand by in case a question comes up, but I would ask that the parties not ask to comment on or respond to comments made by the board, even if you don't agree with those comments. At this point, it's almost like you were. This is a board discussion that you do not have access to opine on. Is that okay for both parties?
It is.
Dr.
Point of clarification.
Yes, sir.
Does this end at the end of the meeting?
I'm sorry, sir?
Do we have to make a
It's almost
decision?
like a gag order, so I'm saying.
Oh, yeah, of course. No, of course. No, I'm sorry. I didn't mean it to be a gag. I just meant that in a normal, if this was a normal board discussion of a normal rule or decision the board had to make, you would not be able to comment. So you had an opportunity to comment and to present your case, and you did it. I think you did it. You both have done it very effectively, and I thank you for that, both of you. So let me now ask my colleagues if they have, first of all, if there are comments and also may I ask, I guess I have to ask you, sir, do we need a motion? Do you know if we need a motion to approve something or what to do?
Well, I think
we do, Ben.
I was going to say, ultimately, I would anticipate a motion, but I think what we want to do is we want to discuss the issues that have been presented to you, so that you can all, as a group, make a group decision.
Right.
That's not easy, but that's what your job is.
But sometimes the decision is easier made if there's a specific motion to respond to. Sometimes the discussion can just be general first.
Department's recommendation serve as a motion?
I'm sorry?
Does the department's recommendation?
Not unless someone moves it.
No.
Okay.
No. And here again, this is an informal proceeding. Whatever leads you to the ultimate conclusion, that's fine. Whether we start with a motion or start with a discussion, my only counsel would be that whatever direction you take, we need a well-reasoned discussion so that the public and the board knows exactly what the basis of your reasoning is, and then a final conclusion. And then I'll have to kind of lean it up to you as to how best to accomplish that.
That's fair.
And can Dave on the telephone participate in the discussion?
No.
In the discussion.
In the discussion.
Well, I'm sorry.
In the discussion, but not the vote.
Right.
Not the
Okay.
vote. It's certainly not a
Okay.
vote. We understand that.
All right.
But yes.
All right.
You heard that, Dave?
I did, sir, thank you.
Well, I am going to make a motion.
Okay.
All right,
Tony, if you'd like to make a motion, then we will entertain
I'll
it.
just preface it briefly by saying that I'm sort of listening to both sides, but for me, I have to look at the totality of the circumstances regarding these turnaround operations. And I personally feel that there are issues where the school corporations in turnaround posture are still responsible for certain activities, such as maintaining facilities at these schools that are no longer being operated under their control. They're still on the hook for participating with things like transportation, maybe catering. So I think that in fairness, we should be as exact as possible with the funding mechanism as it relates to our contracted rate with the turnaround operators. So that being said, I'm going to move that we do have a September 2012 reconciliation count.
Okay, so there's now a motion on the floor, which would basically, in a sense, not accept the department's recommendation, but would accept the recommendation from, in this case, IPS, to do a reconciliation in September and come up with an amount based on that.
Well, Neil, let me correct one thing. I don't have a problem with accepting the department's recommendation here. All I'm saying is my motion is to have a second reconciliation count based on the September 2012 numbers.
Okay, so
assuming we also approve these.
Okay. Is there a second to that motion?
I would second.
Okay, so there's a motion and there's a seconded motion on the floor. Let me invite my colleagues for discussion.
Why? From your perspective?
Just because I think we do have the capacity to get an exact number, and I think that we shouldn't be in the business of sort of giving any type of advantage financially to the private operators. They have an opportunity right now. They've had a year run up to get out there, recruit, get hard numbers, so they have an idea of exactly where they are going into the contracting phase. And I mean, there's always going to be movement, but I don't think it is too procedurally onerous on anybody to go back and do a recount. And they should, if they're in touch with their own kids and doing what they're supposed to be doing during this whole year lead-up time, they should have hard numbers as to where they are to do their own budget.
Because I'm constantly questioning the value and the true numbers of the ADM count. I mean, there seems to be huge discrepancy every year, no matter where you look. If you look at the state, September 17th is the cutoff, and if you look at those enrollments within 6 weeks of that same building, XYZ building, they change. So we're always changing. So the issue comes back to me is this per student file, per pupil. While you guys kept saying 7,356, it said plus applicable complexity amounts. And I think that's critically important, because if we're going to leave 500 kids or 2 kids at a turnaround, and those 2 kids are special needs children, they need to get the services. So let's be honest about the count per student in terms of what they deserve. But I'm not sold on the second count, because it's setting precedent too for a lot of other situations. Will we have to do this for the charter schools? I don't know.
I'm uncomfortable though with, technically, they're not affected students until this program is up and running. And so it doesn't make, I don't know, I guess the statute was not very helpful. But,
Well, they can't make
but
decisions.
defining an
Give you a
affected
framework.
student, but I have a hard time in looking and saying, we're going to make a decision based on last year's numbers when this program does not formally get started.
Right, but last year's numbers is when those students were affected, and that's why we're going to turnaround.
And that's all we have.
Yeah, that's true.
And that's the problem. That's the number we have.
That's true, but they're still not going to be enrolled in this turnaround school until, I mean, not turnaround school, but with Charter USA, until August of this year.
Dan, please.
I'm just gonna, the statute will never make all the decisions, and that's why they said we should make a decision. I want to walk back through how we got here, and I want to look at what motivations we're leaving on the table. The state legislature wanted to make sure, regardless of where the child was born, zip code, whatever, would go to a school that functions and achieves. The schools that we're dealing with today had years upon years of poor performance. Under the statute, everybody knew it. We even went out with consultants to work with the districts and the schools to improve them. Money's been expended, energy's been expended. I'm thankful I went to a number of the sessions this summer at these takeover schools. A school that does not functions very poorly over a long period of time, 6 years here, affects children and their future severely. It affects a neighborhood severely. It affects the economic opportunity for neighborhoods, children, and families severely. Tax base severely. And so the legislature, in their wisdom, said, look, eventually if a school system cannot operate that school effectively for those children, for that neighborhood, for that city, for the community, for the state, then someone else ought to be given an opportunity. Something has to be done. You just can't keep going through the motions. These are real people. So we said, one of the options would be the state board can do a takeover and bring someone in that thinks they can operate the school and improve it. So I want to make sure we put incentives in there that people will want to come in and take on that big challenge, because other people have tried for years under knowledge of law that eventually school would be taken over and they would lose that money. And for that neighborhood and those children, we need to provide a predictable. One of the things I learned I don't know if I learned it, but it was emphasized, let me put it that way. These folks want a school that functions for their children in that neighborhood badly. They've had ups, downs, change administration, new program, that thing, promises made, promises not kept. It's a challenge. And so now we said we've given a year ramp up to this new thing. During that time, what kind of motivations do we want to put in there for people to want to take that on? And also for the players left involved. See, we assumed that the students would be basically the same number there. Has there been a fair shot to explain the new program? Have they been able to talk to all these parents? There's questions about that. So for an operator to come in and get a reasonable shot at running that school well, they have to know what they're going to be dealing with to make the proposal, and to the parents and to that neighborhood. They're going to do a good job. They need some stability. They don't have a big system to spread it around and move it. So I would just hate to take the legislative intent to get these schools improved finally and make it impossible to pull it off. That's my big concern. And I want to watch the motivations this board, in applying this, puts in place to make sure we can operate it well. Because these students in that neighborhood deserve something better, and this is a start at it, and I don't want to cripple it from the beginning. And it's consistent with law. It's consistent with what we've done other places.
Other comments?
Well, I think one of the issues I'm struggling with is the fact that I think it's a fiction that these are the same schools. They're just not the same schools. I mean, maybe in name only are they the same schools. They're going to have several of them totally different offerings, probably mostly or all new faculty members, totally new administrators. I mean, how are we saying that you could really go on what existed that we've already determined failed is an accurate number for what really amounts to a totally new school other than the name? And I just think, we should have a new baseline to reflect the fact that really this is a new school under an old name, to really go by instead of just assuming that, maybe the student that was there last year has no interest in agriculture and science. Maybe students that do have interest in agriculture and science are going to choose to go to that school. So I'm really excited by some of the things that school systems like Charter Schools USA is doing down there and how they're selling themselves. I think they may actually be more successful in attracting people to come to that type of brand with the things they're offering. So by that same token, I think there should be a new baseline, but I understand what you're saying.
I'd like to make a comment if I may at this point. I have some sympathy for the arguments from IPS, but at the same time I'm very concerned about the practicalities of how some kind of reconciliation could work and what to Dan's important point, what the impact of that would be on the turnaround operators and their ability to succeed. I'm also cognizant of the fact that IPS, not alone, like every other district in the state, has benefited and suffered as a result of a traditional funding formula, which is not perfect, which does only count once a year and does kind of look backward. And there have been plenty of instances or years where IPS has lost students but still received funding for those students, and other districts. And there are schools that have gained students and not received funding in the suburbs and have had difficulties with that. This is the way we do business in the state, and this is the way it's operated with its strengths and weaknesses. I'm also have to say that despite Dr. White's assurances and despite the material presented, which I have not had time, of course, to look through, that I believe that there have been significant efforts on the part of IPS to discourage students from attending these turnaround academies, to actively work to limit the number of students who are there. And I think that's disappointing, as I've made the point a number of other occasions at this board. I do not think this is about competition. I think it's about the state trying to intervene, to Dan's point, to help IPS improve the performance of these schools so that they can eventually be handed back and remain part of the district. So I think that has an impact in my thinking about the kind of decision we have to make. Are there any other comments?
I think if we have a recount in September, I think that the takeover folks will suffer and may not be able to get the job done that you think they need to get done.
There's a motion, a seconded motion on the table. The motion is to have a reconciliation, true up a sense of the funding based on the count in September of 2012. All those in favor of the motion, please signify by saying aye.
Aye.
All those opposed, please signify by saying nay. Nay. I'm going to take the presumption of the chair and say that motion did not pass. Do you have any problem with that decision? Okay.
I'll make a motion for another discussion.
Mike, can you talk up?
Yes. Dave, that usually is not something somebody says to me. I appreciate
Thank
that. And my comment is, I think that they need there needs to be some stability in how much money they have and what they're going to project to get them from June to December 31st. That's what my, and so they can make decisions on staffing, et cetera. And I still believe that the numbers that we received from IPS, which were the folks that chose those schools, plus the defaulted students who were going there. So when we go, help me out, Donnan, is that how you pronounce that? Donnan, the number that they gave us is 583. Arlington, the number that I was given was 585. Manual, the number I was given was 445. Howe, the number I was given was 572. So my motion is that each of those schools are awarded those numbers, and this is where I need help from someone, times the $7,331.56. And I'm not sure if that includes the special education dollars or not. Okay, so I'm going to say $7,331.56 plus the appropriate amount of dollars that should follow that child with special education money be awarded to those schools. Did you hear that, David?
I did.
Second.
Do we have any hard evidence on those numbers?
The hard,
Other
we don't,
than
I appreciate
representatives.
that. The hard evidence is, and I guess the hard evidence would be the number, and I appreciate that, the number of kids who have selected that school plus the default numbers, rather than saying the exact numbers.
As of what date? As of what date?
It just feels ambiguous and.
It's very
Very much
ambiguous.
Okay, as of what date, when do they start getting that money, is what
No,
you're
as
saying?
of what date? They selected as of what date?
The numbers that you propose.
Okay.
Because
I'm
you're
saying-
basically moving the
right,
number from September now to another date. so
Right,
we need to
so
know
we're
that.
past May 1, so let's say May 1, and I would say that because, you know, I would say that because that way is not going to change, and again, we're back to being able to giving our takeover folks a number.
I just want to point out, having worked for 7 years with a group of 8,000 parents in the state of Indiana, they don't make their decisions now. So we have May, June, July, and August. And I feel very, very uncomfortable with your motion because of that.
The only thing I'm going to say is this is an advantageous number to the takeovers groups.
We don't know that.
We don't know that.
That's an assumption.
We just don't know
Those
that.
numbers
Like
can change a lot.
Well, I'm just thinking it's an advantageous number to the takeover groups because those are the maximum numbers of the people who have not made a decision. It may be a disadvantage to the IPS group.
People change their minds though all the time,
And that's 4 months.
especially in the,
Summertime.
I can't support that. I appreciate the motion and I
a
respect
second?
the intent, but I can't support it. I think there's way too much uncertainty about what the ultimate attendance level will be, especially as word starts to get out, as we've heard from parents, several parents today. People are starting to hear the news about these operators and what possibilities they offer. So I have to oppose the motion.
Tony seconded.
He did. It's perfectly legitimate motion. So I'm just saying.
All right, okay.
Yeah. No.
I'm just
No.
saying
No.
we still need to.
Oh yes, of course. I'm sorry. I'm just
Your
making.
second is
I'm
what I
just.
said earlier.
I'm both the chair and also participant. So I'm kind of,
You're still legitimate.
You're legit.
there's a seconded motion on the table. Is there any further discussion of that motion? Okay, then all those in favor of the motion, which would basically cap the funding on the basis of the currently of the students who have indicated by default or positively indicating they're going to the 4 schools, capping the funding at those numbers which were provided to us.
Yeah, I'm sorry, what date on whose word again?
May 1st.
On whose word?
My
IPS.
I guess IPS.
Not IPS.
The poor school.
You got those numbers
You
from.
gave us
Where
the
did the
numbers.
numbers
That
come
was April 30th.
Oh, Okay,
Well,
May
May
1st.
1st, April 30th. is
But I
April
mean,
30th.
you get, I wrote those numbers down from you.
April 30th.
All right.
Yes, 2
I
days.
mean, May 1st is
So to
pretty
Neil's,
close.
excuse me, to Neil's question, I guess that assumes that there's been a peer process facilitated by a neutral arbiter to figure out those numbers, or a free market process.
I don't know.
That's what's
Are
different.
we in turnaround mode or pure competition mode when we look at those numbers?
It's-
Those are the numbers that we're using for the motion.
it's
However
very
they were formulated or however they were gotten. So all those in favor of this motion, please indicate by saying aye.
Aye.
All those opposed, please
Nay.
indicate by saying nay. Nay. Okay, once again, I think you'll agree that the motion did not pass.
I'll make a motion to accept the department's recommendation for.
Second.
Okay, there's yet a third motion, seconded motion on the table to support the department's recommendation as submitted and as discussed today. Is there a discussion of that motion?
Is there a second? Oh,
There is a second, yes. All those in favor of this motion to support the department's recommendation, please indicate by saying aye.
Aye.
All those opposed?
Nay.
Okay, I believe that motion passes, and I believe it passes by the number required by the proceeding.
Number required is 6.
Do you want it? Do you need a show? There was only one
Let's
opposed.
do
Let's
it
do a show of
by
hands,
name,
please.
and
All
yes,
those in
okay.
favor, please indicate by raising your hand.
Okay.
1, 2, 3, 4, 5, 6, 7. Right.
Okay.
All those opposed? 1. Okay. So the motion has carried. Thank you all for your participation and for your comments, and thank the board for a good discussion. We now have to move. Do we have?
Here.
Yes. Is everybody okay for time?
Yeah.
I mean, I guess we kind of have to be, but, okay, let's just keep going. Okay. So,
Let me debate.
I know. Do you want to take a 2-minute bathroom break, or? No. Just push? Okay. All right. I'm going to move ahead. May I ask the room to settle down, please? Thank you. I'm sorry, but I know it's been a long session, but, okay, so this is I have to do this by the book to make it official, so please bear with me. This is the administrative proceeding conducted pursuant to Indiana Code 20-31-9.5-3 to determine the amount of state tuition support to be withheld from the state tuition support that would otherwise be distributed to the Gary Community School Corporation from July 1 to December 31, 2012, to be used for the operation of the Turnaround Academy. The reference number for this proceeding is 02-052012. Board members received a copy of the revised notice of recommendation and administrative proceeding that was provided to Dr. Campbell on April 20th, 2012, as well as the department's revised recommendation provided to Dr. Campbell and her counsel on April 30. Gary did not submit any documents for the board's consideration. We will proceed as follows. This is an informal proceeding. A representative of the department will present the recommendation on the amount of state tuition support that should be withheld from the Gary Community Schools, and representatives of Gary will then have the opportunity to present the school corporation's position on the recommendation. Information provided by the parties will be under oath. Board members may ask questions of the representatives. At the conclusion of the presentation and questions, board members will discuss and make a decision. The board's decision will be determined by an affirmative vote of at least 6 members. It is my understanding that Jim Larson will again be representing the department's recommendation. And Dr. Campbell, may I ask who is going to represent Gary Community Schools?
Attorney Robert Lewis.
Okay, Mr. Lewis, welcome.
Thank
May
you.
I ask all of those parties who are going to present information to stand, please, to be sworn in together? Okay, and please, thank you, raise your right hands. Okay. Do all of you solemnly swear or affirm, under penalty for perjury, that the information you provide to the board today during this proceeding is true and correct?
I do. Yes.
Thank you very much. You may be seated. Okay, Jim, we'll start with you, please.
Thank you. Begin again by describing how the department determined its funding recommendation. The recommended amounts represent each school's Roosevelt's September 2011 average daily membership count multiplied by by Gary Community School Corporation's per pupil basic tuition support of $7,686.25, plus the applicable amounts for state special education grants based on the December 1, 2011 special education child count for Theodore Roosevelt Career and Technical Academy. The department made its original recommendation using honors funding. Again, upon upon further review, we removed the honors funding. Now, our recommendation only includes state tuition support and state special education grant funding based on September and December 2011 counts, which are the only formal student counts for state funding purposes for calendar year 2012. This is consistent with Indiana Code 20-43, which prescribes how state tuition support is calculated and distributed. Again, I asked the board to make the following findings. The department's recommendation is consistent with calculation and distribution for state tuition support per Indiana Code 20-43 and 20-31-9.5. The term affected students refers to those students who are attending the school at the time of the most recent average daily membership count. The September and December child counts are currently the only official counts used to determine state tuition support funding. There's no dispute about the average daily membership in special education September or December counts or the amount of per pupil basic tuition support used in the calculation. State tuition support will be withheld from Gary Community School Corporation on 1/6 increments from July to December 2012. Subject to any statewide reduction, our determination on the amount of funding to be withheld will automatically be adjusted accordingly. And finally, the state board, we asked the state board would order the department to withhold the amounts outlined in our April 30th revised recommendation.
Thank you. Are there any questions for the department from the board? Okay, thank you, Jim. Okay, may I now ask representative from Gary, Mr. Lewis, would you like to make a presentation?
Thank you, sir. Good afternoon, everyone. My name is Robert Lewis, and I'm the lead attorney for the Gary Community School Corporation, and it's our pleasure to appear before you here this afternoon. I want to thank you again for this opportunity to appear and discuss the issue of funding for the operation of the Turnaround Academy in Gary. As you know, those anticipated funds are to be withheld from much-needed support monies earmarked for the Gary Community School Corporation. And it's my understanding that approximately $4.5 million has been recommended to this board. And I cannot disagree more with such a recommendation. It only flies in the face of statutory guidelines, but is also unreasonable in its approach. I know that the board has considered the statutory guidelines, but IC 20-31-9.5-3 is the allocation statute, and it says that the amount withheld may not exceed the total per pupil funding for the affected students. This has an obvious meaning to me that the affected students means the number of students that will be attending the Turnaround Academy in the fall of 2012. The statute is clear and direct. There's no ambiguity to it. It's clear on its face. But any determination by this board at this time awarding the amount that's been requested by the DOE is unclear, indeterminate, and in my opinion, statutorily flawed. The number of students being used is the arbitrary ADM count of 1,032. As we look at the number of students that are attending Roosevelt High School at the moment, the number is not 1,032. And I recognize that we're several months away from the 2011 count, but it is not 1,032. And I submit to you that when the count is made in the fall of 2012, that number will not be 1,032. But that's the number that is being given to you as the number to be used to determine the amount of funding to be given to Edison Learning. Many of the students that have left Roosevelt High School since that count of 2011, they have either graduated, dropped out, transferred, or otherwise left the district. They aren't there anymore. They're gone. Those numbers are not there for the upcoming school year and cannot and should not be used. The purpose of the turnaround operator being involved in this process in the first place is to improve the academics of the young people trying to get ahead in life. I submit to you that if you approve the recommended tuition support, you'll be hurting and taking away from other young people in the Gary schools who will remain. As we all know, the dollars follow the students, and we don't know where those students are at the moment. We have no idea where they may be. And I don't think the statute intended that a windfall be given to anyone who comes in and operates this turnaround academy. It's a for-profit corporation that'll be coming in, operating this institution, and the statute already indicates that there should not be any amount that exceeds the per pupil that will be there in the first place. So I don't believe that, given the numbers of 1,032 that you will be operating under, it's an exact count. Of course, we probably can never get an exact count, but a near count of what the numbers that we'll need come the fall of 2012. And again, I think if you award any amount that is approximate the amount that is being requested by DEOC, you're awarding a windfall to the turnaround operator. And again, I don't think that's the intent of the statute. In preparing for this presentation, I researched the issue of affected students. I found nothing. In terms of a court giving a definition of what affected students mean. But I think if you look at the plain meaning of it, the obvious meaning is that those students who will be affected, those students who are attending or will be attending the Turnaround Academy come fall of 2012. And again, at this point in time, we don't know what that number is going to be. And even though we may not get an exact count prior to that particular date, I think there are a couple of ways that we can approach this. One is we can award a temporary and conditional amount to the turnaround operator. The amount that has been recommended is $4 million and $4.5 million. I don't want to presume the amount that you can award, but certainly without awarding the entire amount, you can award a preliminary or a conditional amount, whatever that amount is, until we get to the fall of 2012. And then we can reconcile the amount that is actually to be awarded when 2012 is reached. Another way we can do it is approving the award again conditionally, and then if the amount or the number of students that actually enrolled in the fall of 2012 is less than, or even if it's more, adjust those numbers, and you can order perhaps a refund of any amounts that have been overpaid or adjusted in some other way. I don't think it's absolutely necessary that we reach an arbitrary number such as 1,032 and award monies based upon that particular number. I think there are other ways that we can approach it. I don't think we need to be wedded to the past. I understand that That's a way that has been used in the past. I don't think there is a requirement that we do it that particular way. Everything is discretionary with this board. You can choose to do it this way, or you can choose to do it that way. I believe, however, if you look at the statutory language of affected students, I think we have to be more precise than certainly the approach that has been recommended by that this board has received up to this particular date. I want to thank you for the opportunity to present this particular aspect from the Gary Community School Corporation, and I'll entertain any questions that you may have.
Just a second. You'll forgive me. Mr. Lewis, did you have any questions for DOE? Because I know we afforded that opportunity to IPS, and I think we might have skipped that step. So
I have no question to them.
Okay.
Thank you.
Fine. Yeah.
Yes, ma'am, would you identify yourself?
My name is Alicia Pritchett. I'm the Director of Business Services for Gary Community School Corporation. And what I just want to touch on 2 points, and I know that a lot has been said, but I want to touch on 2 points. I've heard it been mentioned that there is no basis to really set up any guidelines on how tuition support should be dealt with. However, I do want to call to the board's attention when the choice scholarship distribution, and as it related to tuition support payments. When that was a new program, just like this is a new venture that was started September of last year. And actually this is coming from the Indiana Department of Ed. When that program was started, basically that program stated that as it related to tuition support, that as far as the schools that would be participating in the Choice Scholarship Program, that the funding would be based on the result of it would be capped at the $2,011 calendar year cap for all schools in the state. The funding was, as we know, was a pot of money that was set aside by the general legislators, whereby a certain amount was applicable for each student. A reconciliation has been done just recently, as far as the money wasn't just set aside and just say, because these are the schools that participated in this Choice Scholarship Program, these are the schools we're going to divvy up the money to, as sort of like what just happened. What was done was the students that were enrolled at that school received the set aside dollar amount, and any difference was put back into the pot for all school districts in the state to receive. So there's been a basis set by the Indiana Department of Ed as to how a new program was funded. And I just want the board to keep that in mind, as you do have an example to look at as far as a reconciliation being done after, excuse me, my lips are dry, after the actual ADM count date, which was the September count date that was used for the Choice Scholarship Program in September for the 2011-2012 school year. And second point I wanted to make, as I've been listening for the board to consider, would be, as we know from the presentation earlier, that the management, the operators will actually be submitting their final report in June. In this report, there will be a basis as how many employees would be hired. I was thinking as far as their final report. And one thing I just want the board to keep in mind, to be transparent to the public, as if I understand that is what has been mentioned. The board has the ability to say this is the pot of money that's needed to make sure that this school operates, but at the same time, I think that to be transparent to the public, we need to keep in mind that if you know that a person has a budget out there for, say, 50 teachers, then that you know pretty much you get an idea of what's needed for funding. But if you're a for-profit company and you're looking at it whereby you don't know what your ADM count is going to be for September, which would be your funding for January through June of 2013. So therefore, would you want to get stuck, just like how districts sometimes get in that situation with not knowing the unknown. So in June, would you be saying I need 50 teachers, or would you be being reserved and say I need 25 based on my known enrollment as at this time? And I think those are things that need to be looked at, and just to give board some consideration as things that to be looked at, just like this, it's the same handling of what was done in the Choice Scholarship Program as it related to tuition support. As a matter of fact, in September, all the school districts were going to be affected by funding coming from tuition support, being pulled from our tuition support. That was later changed to November, said, no, we're not going to affect your money. And I guess it came from another different pot to say, we will use the funding based on the September ADM count 2011, but it was part of the statute, and that was the intent of the legislators to say any unused money then goes back to the remaining students. It wasn't that whatever the set-aside money was automatically given to the schools who participated in the voucher program and in the Choice Scholarship Program. And I think that same logic should be at least considered here as something to ponder on. Thank you.
Let me ask
Neil?
Yes, Dave. Dave, can you just hold on? Dave?
Yeah.
Just hang tight 1 second. I want to give the
Go
department.
ahead. I got to get off.
Okay.
I apologize.
All right.
I just want to let you know I was hanging up.
Okay. Well, thank you.
Apologize.
Thank you for taking the time today and for participating in the discussion.
Thanks.
Sorry. Jim, do you have any questions for Gary?
We do not.
Okay. Now let me ask the board if there are questions. Yes.
We'll let the board go first, and then, okay.
I don't know how you can compare yourself to a new venture. This has been PL 221, which was initiated in 1999. And so the question begs to be asked, every year, how many of the kids were affected? Was it 1,032? Was it 1,200? 6 years accumulative and then divided. So the idea that you're debating who's affected. It's the children that have been affected in the last 6 years. And the 6 years, having sat on this board, has been a tremendous opportunity for every board who knew their schools were in failing status to react. And what really makes me sad is the vouchers are getting $4,500 and delivering full programs. You folks are getting $7,600 plus the complexity, and we're still here talking about turnaround. So, the arbitrary count may be arbitrary in your mind, but there's 6 years of a cumulative count that every year you've been on either probation or probationary watch. And so this is not news. You're not a new school. Neither is IPS. So I'd be glad for you to, or encourage you to read PL 221 and review what was expected, and that's why we're here.
And we don't disagree with some of the things that you may be saying, but the fact of the matter is, when the turnaround operator is going to get monies for the operation of this particular institution, we just want to make sure it gets the right amount of money. For
I understand.
For doing
I feel the same way about books. Do we ever, evaluate the money we spend in books as being a good return, or, we could kind of drill down in that area. The bottom line is the turnarounds were chosen with the clear intent of improving, and so we want to be equal and fair.
Are there other questions? I have.
Oh, I'm sorry. I think you had a statement you made.
Oh, you have a. I'm sorry. You have.
Not a statement. Myrtle Campbell.
Yeah. Okay, so you had not finished your, I apologize. I thought that the two, okay.
Well,
go ahead.
Thank you.
Okay.
We've had a great deal of discussion, and we've spoken frequently about fairness and equity. And I think that's all we are trying to present here, fairness and equity. And when a statement is made that you've had years, your track record, we have to look at both sides. If we're going to be transparent, and we are all going to talk about equity, we need to look at both sides. What's the track record of persons that are coming in to take over schools? Has there been success? And then when you speak of track records, you have to also take into account the number of variables that are there. In public schools, as we well know, and we say that all schools are public, you have to take into consideration special needs students. You have to take into consideration any child that decides to come in, you must meet the needs of that child. So there are a number of things that are there that doesn't always assist in getting those numbers up that we're looking for. But the state has put into place what we call a growth model. And that talk speaks to gains. What are the gains that are made each year? If you would look at a snapshot of these individual schools each year, you would see that there are gains. But you also can't just look at a school system for, it's not cut and dry. For those of you who have been in education, you know that there are some other things that you have to take into consideration. But going back to the affected student, my question is, if it's not statutorily there or has not been statutorily defined, then is it objective or subjective in how we determine this? That was one of the questions that we asked earlier in this whole process. What do we mean by the affected student? We never got an answer. Now we have an answer today of what the definition is. But that definition should have been in place when this idea was put into place. So transparency, equity, fairness, that's what we're speaking of with the level of funding. The students that will be at Roosevelt Korean Tech are our students as well, and they will be returned to us. So we are concerned about the funding at those schools as well. We want all children to get what they need, but we have to look at it on a basis of the affected students. Are we going to fund, if there are 500 students there, at the same level, or are we going to fund at the level of students that are there? And I think that is the question that I wanted to ask regarding the affected student.
Have you presented any evidence to suggest in any way, shape, or form what number of students will enroll in Theodore Roosevelt in September?
Well, we don't have any exact numbers, but we have some numbers that we think that are somewhat important. Mr. Campbell,
Yes.
Dr. Campbell, I'm
and we
sorry.
have students that have committed. We're saying 1,000. Of course, that 1,032 students, that's currently not accurate because we have the real-time data and it fluctuates. So we are about 1,005 students at this particular time.
Okay.
But in the process of looking at the number of students, and we know that can change, that have committed to the Gary Community School Corporation from Roosevelt into Career and Technical, we have about 426 of those students.
Who have said they will go elsewhere?
Yes.
And do you have any number for the number of students in your other high schools who said they might or they will plan to attend
That might
Theodore
go to Roosevelt?
Yes.
There are no students in the other schools that have indicated that they would be transferring to Roosevelt.
Thank you.
May I ask a question also? I've heard repetitively that 1032 is not a fair number to use because at this point in the school year, there is nowhere near 1032 right now. But if Roosevelt wasn't in this situation and wasn't facing these circumstances, isn't that still funding that Gary should have been accepting for the next school year?
We received that in January.
Right, but I mean,
It would be a shift in your as your population moves. It would be a shift in where the students go between the high schools.
right, but
And that's, again, speaks back to the funding at the corporation level versus the building level.
right. But the argument saying that it can't be 1032 because it's not there now, that wouldn't be an issue if we weren't talking about the turnaround schools.
I'm just sharing that it fluctuates.
And I respect that. I'm just processing the argument about the ADM.
It hasn't fluctuated. I mean, you said it was 10:05 today, so it's changed by about 25. It's not a huge change. Any other questions from the board members directly to either Gary Community Schools or this department? If not, then again, let me ask that we then now move into a discussion phase. which can be facilitated by a motion or does not require one immediately, however the board would like to proceed. I would just ask that the parties at this point refrain from commenting on the discussion that comes from the board. You've presented your cases well, and it's time for us to deliberate and make a decision.
And if I may, I want to emphasize this is a separate case from IPS case. This case is just as important as the IPS case. And I would ask, although I know we've been here for quite a while, that you elucidate your reasons for why you decide what it is you're going to decide. So,
thank you.
There you go. That's my suggestion.
Mr. Chairman, for the sake of the record, in this case, let me just say, number one, I strongly support open and full competition in the educational environment. But it should be fair. I do not agree with using public education funds to in any way subsidize a for-profit education provider. And that's what's bothering me about this funding scenario here. I feel that in a year's time, all of the lead partners have had an opportunity to get out and recruit and have hard numbers in terms of retained students for next year, and that's what they should be paid upon. I don't think it's fair to give them an advantage of a situation where, if we use Gary's numbers, where they may get money for 1,032 students but only have 580. That is, to me, not the proper use of public funds in helping and assisting the bottom line of for-profit corporations. Thank you. With that in mind, I'm going to, for consistency purposes, move to reconcile the September 2011 ADM count with the September 2012 ADM count numbers.
Okay, there's a motion on the table. Is there a second for the motion? I do not hear a second for the motion, Tony. So your motion cannot go forward.
True.
Is there another motion on the table, or does anyone else have other comments at this time?
I'd move we accept the department's recommendation, and if there's a second, we can discuss it a little further.
Second.
Okay, so we now have a moved and seconded motion on the table for further discussion. Is there further discussion of the motion?
Mr. Chair, I want to further elucidate while we put light on the decision. I want to hopefully better articulate. This is a new era. We've been given the responsibility and the duty for every child, regardless where they're at in the state, that we fund an education that works for them. We're creating precedent here. And if you're chronically failing school, you need to do something about this. And if you can't, if it's not possible for whatever reason, point fingers or cast aspersions, we're going to give another organization a try, for-profit, not-for-profit, or it doesn't matter to me there. I mean, can they educate these children? And I want to make sure the proper motivations are in place in that year of transition, if we continue to transition. And maybe the law shouldn't be written. Maybe we're learning that the law should be written about a district. We should take over the district and give it to a different group to organize. But what we have right now before us is a response to make sure we don't put motivations in. We want these neighborhoods and that school and the children's school well served. They need to have a predictable amount of money. We've used this traditionally. This has been the history. This is very predictable. There's been a pattern. That's where it's been established. Every other number seems to be fluid and affected by different behaviors. So to get high-quality turnaround operators to come in and serve a district and the state and the students and the neighborhoods, we have to have a predictable amount. It's based in precedent and history and tradition. It's within, I understand, the definition of the law, and so I think it's the board's responsibility to give these young people in this school building in that neighborhood the best chance possible, and this is what I think we're doing. So that's I said something similar before. I think that's the situation we're in.
I'd like to comment on the motion too. For Tony, I respect your position on this and understand that you've already shown yourself to be a very thoughtful colleague on this board, and we appreciate the dialogue. I tend to support Dan's point that the fact is that we're not suggesting that these schools are going to be funded this way forever. If the ADM count in September 2012 reflects a significant decline in enrollment or a significant increase, the funding from the department will be appropriately adjusted, and the operator of the school, just like every other school in the state, will have to adjust. What we are saying, though, is that until that time, the only solid number we have, the only official number we have, the only number that we use to calculate every other school corporation's funding is the ADM from September of 2011. That's the state law. If someone wants to change the state law, then by all means, I'll be happy to support them doing so. But we're being consistent. We're funding a particular period of time in the only way that we have a record to do, and that in September, if in fact Theodore Roosevelt loses students, they will suffer the consequences of that in their next payment for the 2013 calendar year. So I support the motion. I support Dan's point about letting the operator have some continuity, some ability to plan, some certainty for a limited period of time, but also with a clear understanding that if students don't come to that school will not be funded so generously very shortly thereafter.
Neil, I'll just add it's incumbent upon us as a board to make sure that the contract says exactly that as well.
Fair point. Fair point.
Are the contracts signed?
No. Are there any other comments from the board before we vote? Okay, hearing none, let me ask, remember, there's a motion on the table that has been seconded. The motion is to approve the department's recommendation for the amount of state tuition support to be withheld from the Gary School Corporation. All those in favor of this motion, please indicate by saying aye.
Aye.
Aye. Opposed?
Nay.
And could we have a show of
Okay,
hands,
I'm
just to
sorry,
be
yes,
absolutely
yes,
clear?
okay, yes.
Yeah.
All right, so let me ask again. All those in favor of the motion, please indicate by raising your hand. 1, 2, 3, 4, 5, 6. And opposed?
All right.
2. Okay, so the motion carries by the appropriate number. Okay, this concludes the administrative proceeding. Thank you again to all parties for your participation, especially to our to Gary for your willingness to come down so far. I'm sorry it's such a long way for you to come, but thank you for being here today. Okay, since the administrative proceeding is now completed, I will return the chair to the illustrious Dr. Bennett.
Hi, Ken.
Becky, we have what left on the agenda?
We have 4 things left. I think we can get through them pretty quickly.
Okay, I know Neil went to the restroom, so is Dave, did we disconnect Dave?
Yes, he's done. There's still enough.
You want to go ahead?
Yep.
Let's go ahead.
Okay, the next thing is approval of the administrative process that the board would use to determine noncompliance under 511 IAC 6.2-9-8 subsection D, and Matt will explain that briefly.
Go ahead, Matt.
Good afternoon. I know the hour's late, so I'll be brief in my comments. As the board's aware, 511 IAC 6.298D allows the state board to make a determination of a school corporation's failure to comply with certain sections thereunder. If that compliance is substantiated, the state board has within its authority to withhold additional state funds. What you have in your state board packets, the information, is a process put together, a proposed process for that administrative process, that administrative proceeding. It just generally sets out what the notice requirements are, who the decision maker will be, the process for the hearing, and then the approval of the recommendation. So I submit that to the board for its approval.
Do we have a motion? We have a motion. Do we have a second?
A second.
We have a motion and a second. Any discussion or questions for Matt? Hearing none, all in favor, please signify by saying aye. Aye. Opposed?
Next item, thank you. The next item is approval of a couple of revisions to 511 IAC 15.15-6. Risa, if she's in here. Yes. Yes, she.
We brought the proposed rule changes. This is teacher licensing. We brought some proposed rule changes to you in January and then asked you to make some small revisions in February. At that point, we prepared the document to submit to the Indiana Register for the official legal publication and the announcement of a public hearing date. When we sent it over to LSA to be published in the Indiana Register, we discovered that they have now changed their protocol for formatting, and they sent it back to us and asked us to make some formatting changes and do some renumbering. And so we made those appropriate revisions to the rule, but at that time we also wanted to change an inadvertent situation that we discovered as we went through the rule in the prerequisite licensing for administrative licenses. Currently, the prerequisite amount of teaching experience to obtain an administrative license in Indiana is 2 years. And in making our revisions, we didn't really intend to increase the amount of teaching experience required to get an administrative license. What we intended to do was say you can have this, use the same amount of teaching experience, but we want it to be as an effective teacher, as a result of having evaluations saying you were effective or highly effective. So we have revised that language for the administrative licenses in your rule to say that the amount of teaching experience still must be at least 2 years, but it also must be obtained with an effective or highly effective rating on an evaluation. And we would ask that you approve the edits that we've made and that change.
And that's in here.
Yes.
What did you do? I think one of the questions that we had earlier on this, this is quite lengthy.
Yes, the changes on the prerequisite on the teaching experience start on 45 and go from 45 to 49.
What about what we decide with, was it speech therapist? One of them that had, we had different places where they could get licensed, and one of them was
communication disorders and speech language pathology.
Yes. Did you?
We have communication disorders in here, which is what we call our license, but it is also linked to licensure by the Professional Licensing Agency for speech language pathology.
Okay, do they have to get both?
Yes.
Do we like that?
The school-based individuals say yes. They have asked us to retain it. The special ed directors and the speech language professionals that practice just in schools.
And why do they like it? Because they make themselves harder to meet, because we can't hardly get speech therapists. I mean, if you're looking for a speech pathologist, they aren't out there. And my question is, why are we having them getting double licensed?
Well, the only way that we can issue an emergency permit for someone who is in a program trying to become a speech language pathologist is if we retain our communication disorders license. There is statutory language in the speech pathology enabling language that says that if they have been admitted to a program but they aren't done yet, we can issue a license.
What pages are this on, do you know?
Well, that's in the speech language, that's in a different statutory section, but our communications disorders, is that what you're asking?
I'm just, I think when this first came up, and I kind of go back in my history a little bit, why we were asking them to be licensed in two different places, and the burdens that we were putting on that.
Well, when the initial rule draft that you approved in January had communication disorders and our license out of it, so that they would
say that again.
When you looked at the proposed language in January that we brought you, we had eliminated the dual licensing. We
Okay.
did away with the requirement that they get a license from us.
Okay.
And the Indiana Association of Special Education Directors, ICASE, contacted us early and often.
Is that additional coursework?
No, it's not additional coursework. But it allows us to issue emergency permits to those individuals who haven't yet fully met the SLP licensure requirements so that they can fill the need in the school districts.
Okay. Refresh with me some other areas that might have been questioned that you had discussions with.
School psychologists,
Okay.
who also have a dual license.
Okay.
That's also true of school social workers.
Okay, now talk to
school
me about
nurses.
school psychologists. Are we asking extra coursework for them?
There is an educational component in the school psychologist preparation programs that a psychologist who's going to be in private practice does not complete.
You know, from my point of view, does it hurt anything to postpone this a month just so we can get a summary of and kind of be reviewed on this or not?
Well, we're not approving this rule. All we're doing is getting it ready to publish in the Indiana Register so that we can hold public hearings on it.
Okay.
And there'll be
Okay,
plenty of
I apologize.
opportunity.
and that's fine. It's
I
very-
apologize, 'cause I thought
Well, I'm sorry, I probably didn't explain that
And
fully.
Teresa, would you, just for the board's sake, because this used to be under the authority of the Professional Standards Board, and this is a new function for this board following the last legislative session, can you explain to the board the process you and Rich and your team, what you all are going through to address some of these issues as we move from proposed rule to hearing to potential final rule? Would you mind doing that?
I thought
don't-
I thought
no,
this was final rule.
And I'm sorry, Mr. Pettibone, I probably wasn't real clear, because we're still in the proposed draft stage. This document, once you have acted on it today, will be submitted through Legislative Services Agency to be published in the Indiana Register, at which time we will identify a date for the public hearing. We'll set the location, time, and that will be a part of the official publication in the Indiana Register. We will also open a public online comment site for 30 days so that individuals can comment 24/7 if they want to on what they think of this rule. Additionally, there are a group of education organizations who have asked to provide us some input about their concerns in addition to coming to the public hearing, and at Dr. Bennett's suggestion, we are going to be meeting with them also, but they will also be expressing their concerns as input in the public hearing as public testimony so that you can consider it later.
That's fine. So, you know, since we said we had talked about it in January and February, that's why I felt like all the stuff had been done and this was the final stamp.
This is just still kind of the
Okay.
beginning.
Yeah, okay.
Yeah.
With that, I'll approve that these go to hearings then.
So we have a motion?
Yes.
Motion and a second. Any further discussion? All in favor, please signify by saying aye. Aye. Opposed? Next item.
Approval
you,
of
Risa.
the GQE remediation grant distribution. Wes?
So before I do the state board, I want to ask you for your action. I want to make sure you understand that you did not curse the online program today when you were making comments about it. Online went, yeah, no, I appreciate that. I was, trying not to get too optimistic. I want to let you know that we hit a peak concurrency in terms of we had 42,780 students simultaneously taking the test yesterday at about 9:58. But more.
At about 9:58.
Yeah. Well, I don't have
Mike,
control.
do you not understand that that is about for psychometricians? That's an approximation.
And that was about 12,000 students more than we ever had simultaneously last year at our peak. But what's more impressive to me is that from 8:30 until 1:30 yesterday, we had continuously 20,000 or more students on taking the test for that whole window. So the testing is going well. We're watching issues. Switzerland County has lost its fiber. It's been cut. Talked to them. There are those kinds of issues that still continue to happen.
Excuse me, I just want to interrupt you because I want to make sure we get this for the record. You said they've lost their fiber. That is not an issue last year where it was an issue of the.
Right. Yeah, their fiber optic cable got cut locally. Yeah.
Thank
and
you.
so yeah.
Just want to be certain you got that on the
I thought
record.
you were talking more about their diet.
Yeah.
You were talking about
Okay. So the online is going very, very well, and while I get to say that, it really is the work of thousands of folks out in schools, the technology folks who've made sure schools are ready, the administrators in the schools, including the teachers who are actually doing the administration of the test, who've made the transition. And so they need to be recognized, because I wouldn't be able to sit here and to take credit for the progress that we've made in online if it wasn't for that work that's occurred in the schools. The item that I've brought to you is the GQE distribution. And typically you have seen the GQE remediation grant as an information item, because prior to this year it was in a different budget line item, and it was a line item that was dedicated just to the GQE remediation. And in the change in the budget, this money got rolled into the testing and remediation budget, and we believe it requires your approval, and rather than just informing you about the grant. We've used the same amount of money that was set aside, so that legally, in terms of our due diligence for the graduation test, we're providing the same dollar amount of support to schools for the students who haven't been successful on the graduation test. You've got the attachment that details the amount per school corporation, but the bottom line is that for any student who wasn't successful on either the Algebra 1 or the English 10 test the first time they took it, we're providing $119 for the school corporation to remediate that student.
Wes, is that competitive, or everyone gets it based upon your failure?
Everyone gets it. You can refuse it. Schools can refuse it, but it happened once about 5 years ago. Somebody didn't want to sign, but otherwise, it's essentially the state saying, we put this graduate. This is lay terms, Matt'll, lawyer all over me, but in lay terms, it's the state's put a graduation requirement in place and saying, we're saying that you need to meet this bar, and what is the state doing to help those students who are unsuccessful? What additional resources are we providing? And so this is one way of demonstrating those additional resources for those students who are unsuccessful, where it's specifically for them, and it sits in a separate account in the school corporation.
Just for the record, with all due respect, providing it to the same organization that didn't get them through the first time.
Correct.
So I have a problem with that.
Understand, have no.
Which is why accountability is so important, Neil.
Right.
Move to approve GQEA remediation grant distribution.
Second.
We have a motion, we have a second. Any further discussion?
Do I need to abstain from any of those?
If we all abstain, though, we all have 6. If you and I both abstain, we don't.
Balance
have-
each other out. I'll
Like,
vote on
you-
yours,
I'm
you vote
just,
on
because
mine.
we have to have 6 votes, right?
No, I don't. I think this is a blanket. This is for school. This is.
This is
you don't-
formulaic.
Yeah, it's formulaic, so it
So
doesn't.
we can
yeah,
both-
you're
we
not-
can both-
It's not.
You can both vote. This is a formula.
This is not discretionary.
Okay. I appreciated that, and I was trying to do the math, whether it be both of you, and I backed out.
All in favor, please signify by saying aye.
Aye.
Opposed? Okay. Next, so we have 6-1.
Yep.
Approval to initiate rulemaking for the limited amendment to 511 IAC 7.
This is the special ed rules. We just recently discovered we are out of alignment with IDEA on a small thing in reevaluation requirements. This is to fix that.
We have a motion to approve. Do we have a second? We have a motion and a second. Any further discussion? All in favor, please signify by saying aye. Aye. Opposed?
Motion to adjourn.
And finally, approval to initiate rulemaking.
No, we've done that. We've done that.
one.
That was in the
So I can
discussion
forget
section.
G.
Yeah. Motion to-
Future board.
Where you been, man?
Future board meeting, June
Banned.
6th. Next board meeting's in June.
Next board meeting is in June. We have a motion to adjourn. Second? All in favor? Aye. Thanks to everyone.
Se você disser que eu desafino amor,